Taking a commercial lease. Taking a lease of a commercial property can give rise to significant liabilities, including an obligation to pay for some or all of the costs of structural repairs to the property, whether or not the damage was caused by the tenant or during the tenant's occupation. For this reason, it is important to get legal advice before the heads of terms is signed. Tenants take land as it is. There is no right of refund if the property can't be used as intended. For example, if a tenant takes a lease to operate a restaurant and it subsequently transpires that there is not sufficient planning permission to allow operation of a restaurant, the tenant cannot withdraw from the lease. Caveat emptor. Leases are generally for fixed terms with no right to renew the lease. They can only be terminated on certain dates, and the rent and other charges may increase during the term. Understanding your rights as a commercial tenant is important to ensure that your business is protected from nasty surprises. Landlords often also require large rent deposits or personal guarantees from early-stage companies. These are negotiable, and certain provisions can be included too. For example, allow for the partial release of a deposit during the term if certain covenants are met. In addition to any rent deposit, rent, service charge, and insurance rent payable in advance, a tenant may also have to pay stamp duty land tax, a tax on new leases. The costs of registering the lease with the land registry, landlord's legal fees, and potential fees of their agents. And of course their own legal fees, which probably include the costs of searches of the various registers relating to the property. For help reviewing a term sheet and negotiating a lease, contact Buckworths in London and Manchester via email at office@buckworths.com or our website www.buckworths.com.